Welcome back. Let's look at an important labour issue now, especially for the elderly. A recent Labour Court decision confirms that an employer may fairly terminate a contract of employment based on age. This applies even if the worker is already over the normal retirement age. We're joined by employment law expert and attorney Osborne Molatudi. Mr. Molatudi, thank you for being with us. In this case, the worker involved was 60, I believe. Take us through the details.
Yes, thank you for having me on your show, and good afternoon to your viewers. By way of introduction, the employee in this case commenced employment with a panel beating company sometime in November 2007. The parties had concluded a written employment contract which, amongst other things, contained a provision on an agreed retirement age, which was 60. Come the time when the employee reached the retirement age, the company did not terminate his employment. In other words, the employee continued to work beyond the retirement age. At some point in 2019, the employer then gave the employee notice of the termination of his services on the basis that he had already reached 60, the age of 60, which was an agreed age. And that being so, the employee then felt aggrieved and took the matter to the Labour Court on the basis of automatic unfair dismissal dispute. And unfortunately, the Labour Court did not agree with him because they said what the employer did is in terms of the employment contract and is in terms of an agreed retirement age. In other words, there was no waiver in terms of what was agreed in the initial contract. The employee then appealed to the Labour Appeal Court, disagreeing with the Labour Court, and wanted to argue that the first contract was waived by the employer agreeing to let the employee work beyond the retirement age. So in other words, by so doing, a second employment contract was concluded, and therefore the employer could not terminate the employee on the basis of age. And if the employer does so, then it will amount to what we call automatically unfair dismissal. Unfortunately, again, the Labour Appeal Court disagreed with the employee and said that a defense against an automatic unfair dismissal dispute is very clear, which is contained in the LRA section. It's very clear and unambiguous. It says that if one is dismissed on the basis of age, it will be unfair and automatically unfair unless, and this is very important, unless if there's an agreed retirement age. And that's exactly what the employer in this case used.
Okay, so the employer lost, and it has implications for many people heading towards that age or over that age. But firstly, what if the contract says nothing about a retirement age? What if it's silent? What does the South African law say?
Yes, so what will then happen is what we call a normal retirement age. And you know, the facts of each case will then determine what constitutes a normal retirement age. And some will argue that it will be the age of 60, 62, 63, maybe perhaps up until 65. And in that instance, the employer will then be expected to engage the employee meaningfully in terms of what it intends to do when it contemplates terminating the employee's employment on the basis of age. It is not something that has to do with operational requirements, because that process is completely different, where more has to be done by the employer under those circumstances. So where there is no agreed retirement age, unfortunately for the employer, it will have to engage and get consensus from the employees affected.
What does this mean for everybody over 60 or heading towards 60? I guess you're vulnerable, and it's another reminder to save and prepare for retirement.
It simply means that if your employer allows you to work beyond an agreed retirement age, in this instance 60, you need to alert the employer and say, Mr. Employer, you are now allowing me to work beyond the agreed retirement age, and therefore take this as a waiver of the first employment contract, and therefore we are now entering into a new contract with new terms and conditions, and therefore you won't be able to terminate my employment using the first contract. So in a nutshell, the employee must alert the employer about the fact that by him or her being allowed to work beyond the retirement age, it means the employer is waiving its right to make use of the first contract that contains an agreed retirement age.
All right, thank you. Useful advice. That was employment law expert and attorney Osborne Molatudi.